All right. So the next question is labor law the same as employment law? And that's a fascinating question. And I would say that there really are two different things. And I've never seen an official definition one way or the other. But here's the way I think of labor versus employment law. I'll start with employment law. Most people think of employment law more narrowly than I do. They think of it as the protections afforded by certain statutes and common law protections, particularly wrongful termination based on the two categories that I've talked about, being in a category or engaging in protected activity, and things like other statutory schemes that might help workers and so forth. And I think, again, most people really kind of think of it as lawsuits against companies from employees that affect, discipline, promotions, retaliation, that sort of thing. And I would also include in that non-compete protection or non-compete issues and that nature. Labor law is much more narrow, and I would include in that union negotiations, union settings. That's traditionally what is called labor. Now, the Congress and the state legislatures both created departments of labor within each government, and they typically deal with union matters and other matters. And the Department of Labor regulates the Fair Labor Standards Act, which is overtime and minimum wage, and the Family Medical Leave Act, and and sometimes the Americans with Disabilities Act. So the Americans with Disabilities Act, I kind of think straddles employment and labor law to a certain extent. So I would include in labor law union scenarios, and then those particular statutes that are regulated by the Department of Labor. And you could probably find other lawyers that would disagree about that. Some would say, well, labor is just union settings and everything else is employment law. But that's the big difference between labor law and employment law as labels.